Gilbert has made her presentation interactive. So if you have an answer to her question, please raise your hand and I will give you the ability to answer the question live. So Attorney Gilbert, it's all yours. Take it away.
Thanks, Marla. Hi, everybody. My name is Koshaneke Gilbert. I'm a 2008 graduate of the Law Center, and today we're going to be doing professionalism. As Ms. Dickerson said, it's going to be, the first part is not interactive when I'm just going over a few rules and things like that. But after that, it's very interactive. And I know this isn't a traditional Zoom where everybody can see everybody, but if you make a comment in the chat box or if you raise your hand, if you know how to raise your hand, then you can raise your hand and Ms. Dickerson will call on you or give you the ability to speak and or read your answer out of the chat box. And that way we can keep it going. All right. And I'm gonna share my screen with you all in just a minute, okay. All right. So we're talking about professionalism today. Professionalism concerns the knowledge and skill of the law faithfully employed in the service of a client and the public good. It entails what is more broadly expected of attorneys. It includes courses on the duties of attorneys to the judicial system, courts, public, clients, and other attorneys, attorney competency, and pro bono obligations. While civility is a significant aspect of professionalism, there are also numerous other inherent qualities that make up a professional lawyer, like diligence, honesty, courage, competence, service to the public, as well as the profession. A lot of times people get ethics and professionalism confused, so we'll just give you a little background of what ethics is as opposed to what professionalism is. All right. Legal ethics tend to set forth the standards of conduct required of an attorney. Professionalism includes what more broadly is expected. So ethics is something where you can have, like, you know, a criminal charge, something that you should be doing, that you're required to do, not should be, but professionalism is like what you should be doing. Generally, ethics rules tell us what we cannot do, and professionalism deals with what we should be doing as attorneys. Click anywhere. So just a little bit more of a breakdown. Ethics is the law of lawyering. It's the rules that you have to follow. It's the rules of professional conduct. It's how you avoid malpractice suits. It focuses on misconduct or negative dimensions of lawyering. While professionalism is what you should aspire to be doing, it's how you should behave. You focus on the conduct that strengthens the dignity, honor, and integrity of the legal profession. You don't want people to be saying, you know, lawyers lie and telling those type of jokes, because that goes towards your professionalism. So you should be doing things that, you know, are right. So we'll go over the code of professionalism. The legal profession, The legal profession is a learned calling. As such, lawyers should act with honesty and integrity and be mindful of our responsibility to the judicial system, the public, our colleagues, and the rule of law. We as lawyers should always aspire to the highest ideals of our profession. And this is the code of professionalism. My word is my bond. I will conduct myself with honesty, dignity, civility, courtesy, fairness, will not engage in any demeaning or derogatory actions or commentary towards others. I will not knowingly make false statements of fact or law that are untrue or misleading, and I will clearly identify for other counsel changes I have made in documents submitted to me. I will be punctual in my communication with clients, other counsel, and the court. I will honor scheduled appearances and will cooperate with other counsel in all respects. I will allow counsel a fair opportunity to respond and will grant reasonable requests for extensions of time. I will not abuse or misuse the law, its procedures, or participants in the judicial process. I will cooperate with counsel and the court to reduce the cost of litigation, will not file or oppose pleadings, conduct discovery or utilize any course or conduct for the purpose of undue delay or harassment of any counsel or other person. I will not engage in personal attacks on other counsel or the court or use threats of sanctions as a litigation tactic. I will support my profession's efforts to enforce its disciplinary rules and will not make unfounded allegations of unethical conduct about other counsel. I will work to protect and improve the image of the legal profession in the eyes of the public. I will endeavor to improve our system of justice. I will use technology, including social media, responsibly. My words and my actions, no matter how conveyed, should reflect the profession expected of me as an attorney. I will seek opportunities to be of service to the bench and the bar and assist those who cannot afford legal help. I will be supportive of new members in the profession, and I will stay informed about changes of the law, communication, and technology which affect the practice of law. Okay. So from here on out, it's going to be more interactive. I'm going to give you all some hypos, and then we're going to talk about, what should be occurring, how it affects the code of, or what the code of professionalism says about it. And then we're going to also address like some possible violations that you would have for violating the rules of professional conduct, okay? So the first hypo. All right. Erica Elaine represents Chase Patrol. Chase is employed at Westside Lumber, and he does cabinet work on the side. Chase agreed to build new cabinets for a frequent customer of Westside Lumber. Chase did a horrible job and he was sued along with Westside Lumber for the damages. Erica contacts the customer's attorney as well as Bill Kennedy, who's the attorney for Westside Lumber, and indicates that Chase is going to file bankruptcy. Bill calls Erica and tells her that if Chase files bankruptcy and leaves the lumber yard in a lawsuit alone, that the lumber yard owner might discover some theft charges that would need to be reported that Chase allegedly would have committed, okay? So what should Erica do? Should she ignore Bill because everyone knows he's a bully? Immediately report Bill to the local disciplinary council. Write Bill a letter informing him that the conduct may be a violation of the ethics rule and warn him that if he persists, Erica would have no choice but to report him, or report Bill's conduct to the bankruptcy court. Who knows what he should do, what Erica should do.
You can speak, Ms. Bynum.
It's on mute if you're trying to say something.
Oh, her mic isn't working. Miss
I
White?
see.
Miss
Miss
White?
White. Oh my.
Okay. Mr. Addison?
Mr. Patrick is on there now.
Oh, okay. Professor Addison said answer C.
I see a lot of people in the chat box said C. So I'm gonna just go with the chat box since I don't know what's going on with the other two people that are trying to speak right now. All right. So C would be the most appropriate answer in this case. You always want to give people a chance to do the right thing, but you also want to let him know that you know he's in the wrong at this point. So if we go back to, oh crap. So if we look back at the code of professionalism, here's some things that we can see that might be related to Bill's conduct in this case. The first thing we see that might be related to Bill's conduct is he's not conducting himself with honesty, dignity, civility, courtesy, or fairness, and he's engaging in some demeaning or derogatory actions or commentary towards others. The reason he's not being honest or dignified or acting with civility is because he's threatening to bring up some fake charges against Chase just so that he doesn't dismiss himself from the lawsuit. And then it says, another one is, I'll work to improve the image of the legal profession in the eyes of the public. When attorneys are doing things that are deceitful, dishonest, and just downright nasty, it doesn't look good on the profession as a whole. So what are some possible violations? I don't know. I wanted this to be very interactive, but I don't think it's gonna work. But I'll try. Does anybody know something that might be a possible violation for Bill's actions under the rules of professional conduct? I couldn't see the chat, so I'm not sure if anybody's saying anything. Okay. We'll try this again and see if it works. If not, we'll just use the chat box for the hypos and I'll just do the rest of it. I see somebody put harassment in the box. Okay. So he's gonna get in Rule 8.4 misconduct violation, threatening to present criminal or disciplinary charges solely to obtain an advantage in the civil matter, because he's thinking about bringing up some criminal charges against Chase just to keep him in the civil matter. Truthfulness in statements to others, Rule 4.1. In the course of representing a client, a lawyer shall not knowingly make false statements of material fact of law to a third person. And then Rule 4.4, respect the rights of third persons. In representing a client, a lawyer should not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or methods of obtaining evidence that violates the legal rights of such person. And then 8.3 would be on Erica reporting professional misconduct. A lawyer who knows that another lawyer has committed a violation of the rules of professional conduct that raise a question as to the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the Office of Disciplinary Counsel. So Erica could be, she could have a little problem as well if she doesn't report his conduct to the disciplinary board. All right, next hypo. Amy, she was a high school classmate of Jill. She sees Jill's walking down the street. She stopped Jill and she says, "Hey, I heard you were an attorney." Jill responds in the affirmative. And then Amy tells Jill about a possible case she has against her job. Jill listens and then provides some quick observations about possible remedies as a part of small talk. 2 months later, Amy calls Jill and asks her for an update on her case. Jill doesn't correct Amy, nor does she put together a fee agreement or anything. Instead, she sets up an appointment for an associate to meet with Amy 2 weeks later and take down her version of the facts. She told the associate about the situation and also that there was no fee contract in place as of yet, but she wanted her to get things rolling. Does anybody see any problems with this? You can just put it in the chat. Yeah, don't raise your hand. Just tell me anything that you see wrong with this. I'll give you a minute before I.
Someone said engagement link.
Okay. Okay. I see somebody else say something. Clear scope, clearly communicate the scope. Yep. Correct.
The letter would have to state the scope of representation and fees, etc.
Correct. Okay, good answers. So where, one more. Right, all right, so the first thing we'll look at is the code of professionalism again. She has to be, the code of professionalism says, "I'll be punctual in my communication with clients, other counsel, and the court." So once Amy decided that she was going to represent her, she should have, she had asked her for an update. It took her 2 weeks to get back to her. That could be a potential problem. And again, working to improve the image of the legal profession in the eyes of the public because, she's taking her time getting back to her and clients don't like that. That's probably the number one thing that people get bar complaints about is communication or lack thereof. Right, the clear fee agreement. So those things are going to come in under, under professional conduct violations. So one of them is communication. A lawyer shall promptly inform the client of any decision or circumstances with respect to the client's informed consent, reasonably consult with the client about which the client's objectives are to be accomplished, and keep the client reasonably informed about the status of the matter, promptly comply with reasonable requests for information. And we see she didn't do any of those things. And then the other thing is going to be her fee agreement, if there was going to be one, but she also needs to let her know if she was going to be representing her. So Rule 1.5 says fees, and the first part says a lawyer should not make an agreement for a charge or collect unreasonable fees for an unreasonable amount for expenses. And the factors to be included, and then it has a list, but one of the things that it should say is the scope of representation and the basis of the rate or the fee. So she should have gave her some type of scope of representation, and if there was going to be a fee, that fee should have been included when she first decided that she was going to start talking to her. And then Karen Green says 1.2. What's Rule 1.2, Karen? And I think, if I'm not mistaken, is this? I'm gonna wait for her to respond. Although I do have it up on my screen. I could just, but I have to. Okay. We'll let Ms. Green, because is this Ms. Green that works at the disciplinary council? Okay. She used to work there. I'm sorry, guys. So she's gonna give y'all some good information if I miss something. Marla, Ms. Dickerson,
Yes, ma'am.
can you give Ms. Green the right to speak?
Yes.
Thank you.
Okay, I was trying to put the rule in, but I couldn't flip between the screens. But section 1.2, first you have section A. It just says, subject to the provisions of Rule 1.16 and paragraph C and D of this rule, a lawyer shall abide by a client's decisions concerning the objectives of representation, and as required by Rule 1.14, shall consult with the client as to the means by which they are to be pursued. A lawyer may take such action on behalf of the client as impliedly authorized to carry out the representation. A lawyer shall abide by a client's decision whether to settle a matter in a criminal case. The lawyer shall abide by the client's decision after consultation with the lawyer as to the plea to be entered, whether to waive a jury trial, and whether the client will testify. Section B, a lawyer's representation of a client, including a representation by appointment, does not constitute an endorsement of the client's political, religious, economic, or moral views of activities. Section C, a lawyer may limit the scope of representation if the limitation is reasonable under the circumstances and the client gives informed consent. And D, a lawyer shall not counsel a client to engage or assist a client in conduct the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of a proposed course conduct with a client and may counsel to assist a client to make good faith effort to determine the validity, scope, and meaning of the application of the law. And the reason I said 1.2, because if you go back to section A, it talks about the communication, because you have to communicate clearly to the client, you know, I represent you, what am I representing you to do? And that also includes, like, it could be a written contract. It depends on the type of case it is, because if it's a contingency fee agreement, that has to be in writing. It may not be in writing. It really depends on the scope of what the representation is going to be.
Correct.
And again, so they just had a general conversation. The first question I had was whether or not does she even represent her? You know, it seemed like they was just having like this personal conversation on the side of the street. And then all of a sudden, you know, she calls her and she was like, well, what's going on with my case? And at this point, she should have, you know, I guess at this point it would have been good for her to make it clear, okay, I'm representing you, I'm not representing you. And that's just not professional. It may or may not be unethical, but it's definitely not professional. You know, the scenario.
Okay, that's true. Because the problem was that she wasn't representing her in the beginning, and then she decided that she was going to represent her after she called and asked her for an update on her case. And I think it's important because as attorneys, I put that in there because as attorneys, I know for me personally, I get asked all the time legal questions, and then I just start talking to people and I tell them things, but then I'm like, just so we clear, this is not making me represent you. I'm just giving you a little advice. So for new attorneys, make sure you you get that out there. And that's correct, Ms. Florence. You do not want to represent anybody without signing a contract. And guys, for real, I'm glad that Ms. Green is here and help with that, because I did leave that off. And these are just possible violations, so it's not an exhaustive list. Because I mean, when you start reading the cases from the disciplinary board, it's not going to be one or two things. Like, they find everything that could be even thought of. So you'll have like one or two. It won't be one or two charges. Very rarely is it one or two charges. All right, so for the next hypo. In 2012, the ODC filed formal charges against Bill. Initially, Bill failed to answer the charges, and the factual allegations contained therein were deemed admitted and proven by clear and convincing evidence pursuant to the Supreme Court rules. At that time, no formal hearing was held, but Bill was given an opportunity to file with the hearing committee written arguments and documentary evidence on the issues of sanction. Bill filed nothing for the committee's consideration. After considering the deemed admitted matter, the committee recommended Bill be suspended from the practice of law for 3 years. The Office of Disciplinary Counsel objected to the committee's report and recommendation, arguing that disbarment was appropriate in this case. All right, does anybody see where it falls in under the Code of Professionalism? So the rule that I use is, I will support my profession's efforts to enforce its disciplinary rules and will not make unfounded allegations of unethical conduct about other counsel. And of course, protecting the image, because I don't know what Bill did to get here, but obviously he did something in order for there to be a claim against him. And anytime you do something, the public is watching. So then we go to some possible violations. Does anybody know which violations might be possible in this claim? Just using the facts that you have, not what he may or may not have done.
Someone says the worst mistake was the failure to respond, and then Bill should have responded.
Right.
Needs to respond.
So he needed to respond. All right. Ms. Green said 8.1C. Let's see. So we're doing 8.1C, admission and disciplinary matter, bar admission and disciplinary matters is correct. An applicant for admission to the bar or a lawyer in connection with the bar, with a bar admission application or in connection with a disciplinary matter shall not, and then I skipped A and B because that wasn't relevant, but went to C, fail to cooperate with the Office of Disciplinary Counsel in its investigation of any matter before it, except for an openly expressed claim of a constitutional privilege. Because I mean, you can plead the fifth when you're when the bar is questioning you on things, but you know it has to be specific, and you have to like, you know, tell them what you're pleading the fifth on, and that's valid. So, but I mean, at that point, you are cooperating with them. You're just saying, look, I'm not going to answer any of your questions because you know I might have a criminal matter that comes up that's unrelated to this bar stuff, and I need to protect myself. So, so 8.1C, you guys, you have to cooperate, and I just want to stress this a lot because when you start reading these, especially as of late, all of the disciplinary rulings that have been coming down, a lot of people just have not been cooperating with the bar. Like they'll send them their notices and they send them certified and they don't pick them up, and then they'll get in contact with them and they'll give them another address and they'll they know they have it because they sent it certified, and then you just don't respond. Then they give you an opportunity to come to the hearing, and you don't go to the hearing. I mean, at that point, there's nothing they can do but deem everything that is alleged against you as admitted because you refuse to participate in this. And once they do that, the sanctions are harder. They're more stiff. So a lot of times where, like in this case, the hearing commission was saying, let's go ahead and just suspend them for 3 years, but the disciplinary council was like, no, we should go ahead and disbar him. And a lot of times that's what happened. You know, they'll end up with, you know, a disbarment, albeit it may not be a permanent disbarment. It's disbarment nonetheless. So you don't want to, you know, put yourself in that position. All right, next hypo. Your best friend is struggling to make ends meet. I'm sorry, I cannot see this with my face. Okay. She decides she is going to place her child's father on child support. She wants me to represent her and sue her child's father for child support. I've never done anything related to child support. I inform her she'd do better getting an attorney that's familiar with her child support laws. However, she insists that I represent her. I don't want her to be upset with me, so I agreed to help her out just this once. So at this point, this is a little different. At this point, what can I do for my best friend, or what should I do? Who has some suggestions on what should be done in this situation? Everybody who has a suggestion, put it in the chat box. We'll go through them.
Someone says ask for help from a seasoned attorney.
Okay.
It's okay for her to represent her, but she needs to talk to someone who knows family law and have them assist.
Okay.
Maybe bring in a lawyer with more experience to help. Tell her you will help her find an attorney.
Okay. File a limited representation. Okay. Learn how to do child support and talk to someone with experience due to rule requiring competence. Okay. If not comfortable, set boundaries. These are all good answers. Give her a referral that handles that subject matter. Okay. Ms. Florence said we've all been there. When we start practicing law, we barely know what we're doing, but it's good to seek experience and ask them for help. That's correct. All right. So those are all good answers. And then this is what I'll do next. I decide I'm going to go ahead and take the case. And it soon becomes apparent that I'm in over my head. So I need to get someone to help me, and I get a friend who does family law work, but he's going to charge a fee. I explain the situation to my friend, who becomes upset and tells me she does not want my friend involved because of the cost. Is it too late for me to now charge her for helping her?
No, from V. Riley.
Why not?
We have. Oh yeah, you're asking for her to put a bar complaint on you if you want to charge her after the fact.
Anybody else?
It may not be too late, but she will not pay you either, I don't think. So this is good. We have some different of opinions.
Yeah.
If you're taking on a case, advise the person this matter is more costly with time and effort, and a flat fee is needed. So I assume that means that this person owner is not too late.
Come back and say if I'm gonna, but now just so we all understand, I've already agreed to help her, but now I was gonna help her for free, but now I done brought somebody else on who's charging me, so what do I do in that situation is what I'm...
Professor Addison said, must be careful as long as she agrees to the fee.
Ms. Green, you don't have an opinion?
Could you expect pro bono at this time? Could you elect pro bono at this time? Ms. Green said, yes, she does have an opinion. Ms. Green about to, there we go.
It says, well, if that's the case, then you can discuss the matter with her and put a fee, but I truly doubt that she'll pay it.
Okay. So some of the issues I see, well, whether or not, first of all, in order for an attorney to bring in outside, counsel for assistance, the client has to approve it, whether or not the fee is of no consequence. So if she says, no, I don't want the other attorney helping, because then she can't allow another attorney to help. Now, if she's not competent enough to do it on her own, she needs to withdraw. Now, so it's simple as that. But she can also, say if the reason why she needs money is to get outside counsel, she's not going to be able to get the outside counsel. So at this point, she should communicate to her. Don't keep hiding and running. Just let her know that, I'm trying to assist you with this. I'm not able to do it. At this point, you're going to either have to pay someone else to do it. I'm not going to be able to do it. And it's not simply because, I want to charge you money. I can't competently represent you. I'll be in violation of Rule 1.1 if I continue to do this on my own.
Okay. So I came back and I agreed to pay it out of my pocket because I really, really need this help. He does a fantastic job. However, my best friend refuses to accept his work, becomes very angry about the fact that he's still involved in the case, and demands that my friend be removed from the case immediately. All right. So where are we on the code of professionalism? I was trying to do this pro bono at first, so that was a good thing because it says I will seek opportunities to be of service to the bench and the bar and assist those who cannot afford legal help. And then I paid out of my pocket, so I still was trying to be, a good person. And then the possible violations. And I know Ms. Green gave us some, so. Does anybody else see a violation? Let's see what somebody says. Oh, somebody said I should have told her to use legal aid if the cost was an issue. Okay. (1.1) and 1.2. Something like that. Okay. So we got Rule 1.1 competence. It says a lawyer shall provide competent representation to a client. Competent representation requires the legal knowledge, skill, thoroughness, and preparation reasonably necessary for representation. And then I left out 1.2 again because I think about that. Oh, I went too far. 1.4 communication. I should have told her immediately when I started to bring on my friend, and then she could have decided if she wanted my friend to be a part of this or not, because I have to just inform her of anything that's going on with her case. And then the fees, we should have talked about the scope of representation in the beginning, and if I was going to charge her a fee or not. And then I can't decide in the middle of representation that I'm going to charge her a fee. All right, Jamie graduated from As you'll see, in May of 2020, she struggled through Jamie struggled through law school because it's me. And now he's been sworn in as a member of the Louisiana State Bar. He decides to hang his own shingle and try to make it as an attorney, but he has zero experience as an attorney, but is now taking cases. Does anybody see a problem with this? Or what should we be doing in this situation?
He should have taken the bar exam.
Well, he didn't have to take the bar exam. That's through no fault of his own. And now he's practicing.
So he's part of the diploma privilege class.
Correct.
Someone says seek assistance from more experienced attorneys.
Okay. A lot of research, find a competent mentor, take CLEs and possibly a mentor. CLEs are a great idea, guys. And as a first year, you have to take, more than everybody else anyway. So make sure you get your CLE hours. Consider completing the TIP program prior to taking any classes. Any cases. What did Jason Thrower say?
He needs to pray hard.
Oh, okay. No, as long as he seeks help and believes he can competently represent clients, go to the courthouse and observe. These are all good suggestions. Going to the courthouse is a good suggestion. What about you? What can you do? Must be careful of protecting the image of the profession. That is correct. But what can you do, Miss Addison?
Think you're talking to Professor Stefan Addison?
Yeah, is that a female? I'm sorry.
No, it's a male.
I'm sorry. What can you do, Professor Addison? Oh, it is a male. I'm sorry, sir. Continue to stay knowledgeable in the areas of law he has chosen to practice. Okay.
I know when I first started practicing that I linked up with a couple of experienced attorneys and received help from them. But then I would go to the courthouse and I would literally sit in the courtroom all day and see how everything operated. I would take notes and copy that, which I found helpful. And then I would go through the clerk of court website and look at all these different cases that have been filed, and I make copies. That's what I've been doing, taking CLEs and going to the courthouse to observe. I'm a May 2020 graduate, also reaching out to seasoned attorneys. Someone who is another attorney says offer to mentor.
Okay, that's a great answer.
Attorney V. Riley seeks some sort of mentorship from a seasoned attorney. Professor Addison, you're on now. Jason Thorough joined various professional organizations like the local bar to link with other seasoned attorneys.
Professor Mason said she wanted her name shut up. Professor Mason said you should offer to mentor.
That is what Professor Angela Mason said. Gina Signorelli, consult and document. You're very welcome, Professor Mason. I will indeed make sure that I say people's names and their comments as well.
Okay, Mr. Professor Addison, what are you going to do in this situation? As who you are right now, not as Jamie.
I don't know if Professor Addison is paying attention to us.
It's like he's trying to talk or set up his microphone or something. He in his office, he probably doesn't have a microphone.
Okay, so we'll come back to Professor Addison.
Okay. So anyway, what I was looking for is, let me close this out because I can't move once I had it on. Is what we should all be doing as seasoned attorneys. Which is being supportive of new members in the profession. So if you're on here and you're a seasoned attorney and you've been out a while and you know there are a bunch of new attorneys who need help, you should be finding somebody and offering them some mentorship, offering to help them, give them some of the documents they need that, to help. Maybe they need a petition for damages or, a petition for divorce or something, and then you have it, and you should be sharing that with them or telling them how they can access it. I think Professor Mason had the correct idea. You should be offering to mentor anybody in need of help. That's how we support the profession. That's how we change the image of the profession. And that's how we make sure everybody who comes out and who starts practicing is competent and able to provide great legal services to those who might need it. You also have to remember that you should be doing some type of pro bono work every now and then. Just give up a little bit of your time and do something that that helps somebody else for free.
I also have a couple more comments. Mr. Matthew Foster said that he pulls previous filings from courthouse and from the courthouse and like cases, and he also has a form book. Professor Addison thought that we were able to hear, but he said he would consult a experienced attorney before he put up his shingle. And Marcus Root said make some friends and talk to them.
That's correct. And going to the courthouse and printing out the other things that you need is good. If you try to do it online, they're going to charge you for those things. But if you go over there and you do it yourself, you might just have to pay for the copy, which is way less expensive than paying a monthly subscription to have access to the online documents for the courthouses. So you may want to think about doing that. Also, if you're alumni, just because, you can join our alumni Facebook page and you can ask for whatever you need in there and somebody will help you. All right, are there any questions, comments, concerns? Yes, we have experienced attorneys here that can help answer questions as well.
Professor Mason said, great presentation, very informative. Ms. Sharon Florence said, nope, you did a great job. Actually, she's Mrs. Williams. Ms. Sharon Florence Williams, nope, you did a great job today. A good job. Andrew Bogard said, thank you for the presentation. And
thank you all for coming, and I'll see you guys next time.
Thank you, Mr. Jared Nelson. Amazing presentation. SULC always comes through. Great job. Mr. Marcus Roots, thank you. Miss Angeline Brown says thanks. Gina, thank you. Jason Thorough, thanks, good job. Karen Green, thank you, wonderful job.
And thank you, Miss Green, for coming through with those answers. I'm sure everybody appreciates it.
Angeline Brown. You remember her, Professor Mason, Angeline Brown? Kiana Wilson Bonham, thanks. My pleasure. I do. Yes, so thank you all. And what I want to tell you are, this is a series that I, along with the members of the CLE department, have put together, Becoming Fierce in the Practice of Law. This will be an ongoing series from here into eternity, where we offer information on the practice of law in different areas. So the next installment of Becoming Fierce in the Practice of Law is Discovery, which will be presented by Attorney Christopher Washington. So I hope that everyone can also attend that, and stay tuned for our end of the year CLE information that should be out within the next 2 weeks. If y'all have the date for the discovery is October 23rd. So we have the Becoming Fear series happens every Friday, 12 to 1. So, and also if you need any help, any information on CLE, we also have a website now. You can go to www.sulc.edu/CLE, and I'll put that in the chat. And that contains all the information on upcoming CLEs as well as, I typed it wrong, I'm sorry. That contains all the information on upcoming CLEs as well as your ability to register. So, so thank you, Professor Mason and Professor Gilbert. And if you are, I especially like to highlight our SULC alums, but if you're interested in putting on a CLE, please just contact me, mdickerson@sulc.edu. And I'll be more than happy to put you on as a panelist or speaker. So thank you all for your support.
All right, well, good job. Thank you.
Thank you. Y'all have a good evening. How do we record for this CLE? I will submit to the Louisiana State Bar Association. So that's how you will get your credit. Thank you, Mr. Foster.